Welcome to Discovering the Law. My name is Lucy Rivera, and I am the host for this program. This program can be viewed at www.discoveringthelaw.com. And today we have a very special guest, Professor Charles Kindregan, who is a tenured professor at Suffolk University Law School. He co-authored a book along with Maureen McBride, and it's called Assisted Reproductive Technology, A Lawyer's Guide to Emerging Law and Science. Professor Kindregan, very pleased to have you here today.
It's a great pleasure to be here.
You're a tenured professor for family law, among other things, at Suffolk University Law School.
And you're a distinguished graduate of that law school.
And thank you for coming.
My pleasure.
I would like if you would talk to our audience about your book a little bit, where they can obtain it, what it is about.
Well, the book is published by the American Bar Association. It's in Chicago, and I'm sure it's available at Amazon and all of the other outlets.
And you can
But I'm not here to sell books. I'm here to talk about this fascinating subject.
And thank you for our studio who put a picture of the book up there. We appreciate that. You could all see the face of the book that Professor wrote. It was just up on our camera. So Professor, what is reproductive technology? What is?
It is assisted reproduction in the sense that it is a medical technology used by people who want to have children,
yes,
but cannot for any number of reasons. I guess we can talk a little bit about that in a minute, but who uses this technology. But that's really what it is. It's people who seek medical intervention in order to have a child. And so it's called assisted reproduction, as distinguished from sexual reproduction.
Right. And who uses this assisted reproduction?
Well, actually a host of people use it, and it's gotten to be very, very common, not just in the United States, but even internationally in India and Europe and Latin America, as well as here in North America. And it is a technology that first, and most obviously, it's used by people who can't have children because the woman might be infertile or the man infertile or both of them. And so they need to call on medical help if they want to have a child and grow their family. But in addition, it's used by many other people for different reasons. For example, it's used by people who may have some kind of genetic condition and they want to avoid having a child with this medical condition. And as a result, they will seek donors who will provide eggs or sperm or embryos so that they can have a child. So it's another form of assisted reproduction. And of course, here in Massachusetts, we're one of 7 jurisdictions which allows same-sex couples to marry. And same-sex couples, I guess you would say, are by definition, because they won't have sex with a person of the opposite gender. So for them, this is really the only way that a same-sex married couple can have a child by one of the various technologies, and there are a number of them, by which they can have a child. So it's very important to people who really want to have a child or a number of children. And the only way they can do it is by the medical technology, some form of medical technology, which enables them to have a child.
Well, think about all the implications giving rise to this technology with the fathers. And is this legal?
Oh, that's a great question, and that's a lawyer's question, Lucy. But let me tell you, it is in some states of this union, some forms of assisted reproduction are not legal, or at least they're not legally enforceable as a contract. New York, for example, does not allow a surrogacy. Other states have complicated laws, to put it mildly, which are so complicated that it's not likely that people are going to use the technology in those states. So they often come to a state like Massachusetts, or a state like California, or Illinois, which tend to be more agreeable to, in their laws and practices, to allow this technology. This reproductive system is, of course, it's both legal and it's medical. And so the issues get complicated on a state-by-state basis. Alabama is the state where the Society for Reproductive Medicine is located. And so it is used there, even though they don't have very much in the way of law on the subject. In Massachusetts, we have a statute, and I can talk about that a little bit if you'd like. California has many different laws and statutes. So it varies from state to state.
Yes, would you please talk about that statute in Massachusetts about the...
Well, yeah, the oldest form of assisted reproductive technology is what we call intrauterine insemination.
Okay.
Or it's sometimes and popularly called artificial insemination, which is a terrible word because obviously as a means of producing a living child, there's nothing artificial about it. But the fact of the matter is that it has been around for centuries. Arab societies used it to reproduce animal husbandry. And the oldest case that we were able to find in the United States dates back to 1862. So it has been used for a long time.
Right.
But it wasn't until the 1950s that this really got to be much more prominent. And states began to enacting laws, and we did here in Massachusetts. And our law says that if a married woman uses a sperm of a donor, somebody who sells his sperm at a sperm bank, and her husband consents, then that child is the legal child of her husband, even though it's not his biological child. So that's our statute. And it's interesting because it has just recently been, even though it's an old statute, goes back to the early 1960s,
right.
Just recently interpreted by our state Supreme Court. And so this is the most common type of assisted reproductive technology, use of donor sperm to make a woman pregnant. Now, we know that women may want to become pregnant for any number of reasons. They want to have a child, basically. But suppose you have two women in a same-sex marriage.
Exactly.
It's perfectly legal here in Massachusetts.
Yes.
And so those women are likely to seek intrauterine insemination so that one of them can become pregnant. And now if the other one, her spouse, consents, then that woman also, even though she has no genetic connection, she's not the birth mother, she becomes the legal mother under this statutory arrangement. So that's just one example, I think, of the law trying to accommodate the interests of people who want to do something with their lives, namely have a family and have a child.
Yes.
That's only one kind of assisted reproductive technology. There are many other kinds as well.
Yes, and tell us about the other kind.
Okay.
I think you mentioned.
And we actually have a better record of some of the other kinds because these, the intrauterine insemination often takes place in a clinic or in a physician's private office, and there's no record of it unless and until somehow there's a dispute. The husband says, I didn't consent to that. You got pregnant some other way, or something like that. So there's not much in the way of public records on this, but other forms of technology are more regulated and by law, and therefore we have better records. So as of 2003, there was a survey done that found that thousands of children had been conceived, for example, by another technology called in vitro fertilization.
Yes.
Now, the older members of your television audience here may remember, long before your time, Lucy, it may be aware or remember a time when a child was born in England almost 30 years ago, and she was the first so-called test tube baby. That's what they called her.
Oh, okay.
And they called her a test tube baby because literally in vitro fertilization means that, that an egg is produced by a woman, they call that harvesting, is harvested from the woman and is put into a test tube, and literally a sperm is injected into that, and the result is an embryo, what we call an embryo. Technically, it's not an embryo, but I won't get too far into that. It's an embryo in one sense, that it has all of the genetic makeup of human life. And so that embryo can then be inserted into a woman, and she can have a child.
Yes.
Or in the alternative, it can be cryopreserved, frozen, deep frozen, treated. And then it can be put into a storage and used at some future date. So everybody was aware, I think, a few years ago of a big scandal in California where you had a woman who had 6 embryos implanted in her.
Oh, right.
And she was called, the popular language, the octomom.
The octomom.
And 2 of those embryos split, so she wound up being pregnant with 8 children.
Yes, and that's...
And she already had 5 or 6 kids, and she was only 35, so there was no medical reason for inserting so many embryos in her. But she gave birth to all of those kids. That's a misuse of the technology, I think most people would agree, but you can't regulate that by law. For example, many women who are at the end of their reproductive lives, a woman who is maybe into her 40s now,
Right.
and it would not be uncommon if she's using this technology to try to become pregnant for the physician to insert 2 or 3 embryos
Okay.
to increase the possibility that she's going to have a child. Now, inserting 6 is crazy.
Right.
And it is crazy when a woman, I think she was 35, she was had many years left of her reproductive capacity.
And not only that, but that's expensive. Wouldn't that be an expensive procedure?
It is an expensive procedure.
6 times, and health insurance doesn't cover that.
Well, in Massachusetts it does.
Oh.
Massachusetts is one of the few states that requires health care plans to cover reproductive services, and
Very good.
including assisted reproductive services. There are some other states too, but not too many. In most cases, and that's why this technology is sometimes said to be used by wealthier people, because they're the only ones who can afford this procedure. But if a couple has, one of the parties in a relationship has health care, insurance, then they should be able to get services here in Massachusetts.
Interesting. Well, today we are with Professor Charles Kindregan. He is a tenured professor at Suffolk University Law School, and he's here to talk to us about his book and about his new course on reproductive technology. Professor Kindregan, from all this, there's probably all sorts of legal...
It's really not a new course, by the way.
It's not.
I've been teaching about reproduction, parentage, and so forth since the 1960s at Suffolk Law School. We're far ahead of everybody on this.
Well, Suffolk is far ahead.
But it's new to many law schools. I mean, I know people now teaching at Cleveland State and Minnesota and other schools. So other schools have now taken up this course because it's important to lawyers to understand what their clients are going through and what the legal ramifications of that are.
Yes. And Professor, so tell us a little bit more about surrogacy and the other ways to have this.
Surrogacy means that one woman will carry the child, will be the birth mother for another child, for another woman. Why would a woman do this? Well, some women don't want to be pregnant. They may have health conditions that may preclude their carrying a fetus. They may have a history of miscarriages, and so they look for this other alternative of having some other woman they hire to, usually it's a hire. It could be a relative who's doing it for nothing, one sister for another, something like that. We've even had cases of a mother carrying her daughter's child, in effect their own grandchild.
Well,
So there are all kinds of potential issues here. But that's what surrogacy is. And surrogacy probably was around for a long time, but nobody knew about it.
yeah.
And it wasn't until the 1980s when there was a very famous case in New Jersey that hit the national news. And it seemed so bizarre to people that a couple who wanted to have a child would hire another woman to carry their child for them. And that was the so-called Baby M case, a very famous case. And in that case, they hired a surrogate, and her own egg was used. The sperm of the husband who wanted to have the child was used to impregnate her medically. And she became pregnant, and she had a child, and then she decided to keep the child. And that, of course, is what touched off the big, very famous Baby M lawsuit. Now, at that point, the mother, the birth mother, who it was not clear whether she was the legal mother or not, she was providing the service for a fee for the couple who hired her. But she said, I'm the birth mother. So in some states, that's the rule. If you give birth to a child, then you're the legal mother. But in most states, there's no such law. And therefore, the question before the Supreme Court of New Jersey was, who's the mother? Is it this man's wife? He's clearly the father. He provided the sperm. Is it his wife? Or is it this other woman who was hired as a surrogate? Now, one of the problems with that case as legal precedent is that the birth mother was also the genetic mother, because they didn't use a donated egg. They used the woman's egg, the birth mother's own egg. And therefore, she was legally the mother in the sense of the genetic mother and the birth mother, and that makes a very strong case for her. And the Supreme Court of New Jersey ultimately ruled that she has maternity rights in that child. So she got visitation, and the husband, the father of the child, actually got legal custody, but she got visitation with the child because it was her child. When we talk about surrogacy today, we are talking about, in most cases, a situation which avoids this problem because the birth mother is not the genetic mother in most of these surrogacy cases. She's what we call a gestational mother. And that means that her womb is used, but she has no genetic connection to the child that she carries for this other couple. And that avoids this, the big potential problem of the status of the surrogate. If surrogacy is legal, I mentioned that in New York, they have a law that says surrogacy contracts are not enforceable. Michigan has a similar law. So there are some states where you would not want to use surrogacy as a assisted reproductive technology, because even if the birth mother has no genetic connection, she's still the birth mother, and some legal rights accrue to her from that technology. Now, can I just add one thing about that?
Yes, yes.
That it seems to me that in a state like Massachusetts, where we have no law governing surrogacy.
And that's what I wanted to ask you.
Okay, ask away.
Seems to me like there is a gap, there's some rise to opportunities for legislation in Massachusetts on this field. And I wanted, if you would comment on the current status of this law in Massachusetts and the opportunities for legislation.
Okay. In Massachusetts, we have no state statute. In other words, the state legislature has not enacted a law governing surrogacy. But of course, these cases come to the courts. And so the courts have to decide them on what you and I as lawyers would call a common law basis. And the courts pretty much in Massachusetts have held that surrogacy agreements, at least gestational surrogacy agreements, are enforceable. And for example, a famous case involving a couple here in Massachusetts, they wanted to have a child, They hired a surrogate. All of them went to the family court while the woman was pregnant, while the surrogate was pregnant. The husband, the wife, the surrogate, and a lawyer from the hospital where the child was scheduled to be born. And they asked the court for a ruling, a pre-birth order, we call it, that if this child is born to the surrogate, who are the legal parents? It will be the intended parents, the man and woman, husband and wife in that case, who started this whole procedure so that they could have a child. So Massachusetts recognizes at least most of these surrogacy contracts. What is not clear, although I think it's probable, is that if this technology is used by a same-sex couple, would the courts also be sympathetic to them? And given the language of our same-sex marriage case, the Goodrich case, it seems to me that those people would be treated just as a heterosexual couple would be treated. But there's another problem.
Tell me the name of that case again, Professor, that you mentioned. Is it the Goodrich case?
The Goodrich case is
Commonwealth versus Goodrich?
Yes, Goodrich versus the Commissioner of Public Health was a decision by the Supreme Judicial Court of Massachusetts that said for all purposes, a marriage of two people of the same sex who are otherwise qualified to marry, they're not married to somebody else, either of them, can marry now in Massachusetts. And of course, that's a landmark. That's the first case in the United States that recognized that right. So,
I think I interrupted you when you were going to talk about the opportunities for legislation.
I'm used to that all the time. Don't worry about it, Lucy.
By me, right? Where would you suggest could be an opportunity to regulate this?
Okay.
Is some new technology or not? Or?
Can I just follow through on the last thought? Because Massachusetts is favorable to the granting of pre-birth orders, people from other states, for example, New York, now come to Massachusetts and arrange to have their child delivered in a Massachusetts hospital, and they get these pre-birth orders. And there's a Supreme Court decision allowing that as well. You might say, well, why New York residents? They're not living in Massachusetts. But our courts are more favorable to this technology, as the California courts are too. You asked me about potential legislation?
Right. Like where do you see that there could be some good grounds for legislation?
It's a good question. Because while some states have legislation, many do not. You can understand politically this is a tough issue for legislators to grasp and to work with. Because there are people who have religious objections, ethical objections, all kinds of objections to some of this technology, not necessarily all of it, but maybe specific procedures. And for example, there are some people who object to the storage of embryos, which they say then is like storing a human being, or somebody, at least a being who's not yet born, but does have all the genetic makeup of a human being. So there's an awful lot of moral and ethical issues that confound this whole area. I happen to have been the chairman of the American Bar Association Committee on Assisted Reproductive Technology. I'm not anymore. Back when the American Bar Association decided to try to draft a statute. And we did. There is now a model act, the American Bar Association Model Act, which we would hope that legislators would consider, although it's difficult. And might say, well, why do we need a law if it's working? Why start bringing laws in and regulating people? Well, of course, the answer really is because we don't know what the status of the children are. And it's the interests of the children that need protection. The adults make their own contracts and they have to live with them. But these children who are conceived, and there are thousands of them every year, may be in a kind of legal limbo. So we actually proposed a whole code, which is now available for state legislators to consider.
Very good, Professor. Well, this is a really interesting subject, and I find it fascinating, and your knowledge is definitely a bit in depth I think we need 2 shows for this topic.
Well, we haven't even talked about India and Canada. And
We really haven't, but unfortunately our time is up, and we have to go now. But thank you for this, Professor, and thank you to all of you for watching another episode of Discovering the Law. And we learned a lot from Professor Kindregan today about reproductive rights and all these issues that can come up. Please view this program at www.discoveringthelaw.com. And my name is Lucy Rivera. I'm your host today, and I can also be reached at lucinda.rivera@discoveringthelaw.com. Thank you for watching.